My name is Dean Joe-Santos Balagtas Bisquera. I am the incumbent Vice President for Legal Affairs and Dean of the College of Law of the University of Manila. I obtained my Bachelor of Laws from the University of the East, cum laude and class valedictorian. I am also a Bachelor of Business Administration and a certified public accountant from the University of the East, graduating as summa cum laude and finalist in the 10 outstanding students of the Philippines during my time. I hold a Master of Business Administration degree from the University of the Philippines in Diliman, where I graduated as class valedictorian and with a grade equivalent average of magna cum laude. I have about 40 years in the corporate world as a senior finance manager in companies that include Fuji Xerox, Motorola, Esso Petron, and GlaxoSmithKline among the companies where I occupied senior management positions. I have also been a bar reviewer and a law professor since 1994 and an MBA professor in financial management at De La Salle and the University of the Philippines from 1975 for about 10 years at UP and for almost 36 years in De La Salle. Today, I'd like to share with you my view on the ABS-CBN controversy, zeroing in on the issue of whether or not ABS-CBN is a 100% Filipino corporation in mass media on the basis of the citizenship of its major stockholder, Mr. Gabby Lopez. My hypothesis is that ABS-CBN conforms to the need for a media company in the Philippines to have 100% Filipino insofar as its stockholders and senior management is concerned. Gabby Lopez is a natural-born Filipino citizen. To qualify him to be a major stockholder and part of management of ABS-CBN as a mass media company. It is also my position that while he is an American citizen under U.S. law, he is also a 100% Filipino citizen, a natural-born citizen under Philippine law. And his being an American citizen does not in any manner affect the fact that ABS-CBN continues to be 100% Filipino because Gabby Lopez is a natural-born Filipino citizen. The requisite of Filipino ownership in mass media is clear. Lopez is a Filipino citizen and can own therefore ABS-CBN. Nothing in the Constitution demands simultaneous exclusion of citizenship of a Filipino who at the same time may be an American citizen under U.S. law. The Philippine Constitution under Article 16, Section 11, Paragraph 1 provides the legal basis of demanding that mass media corporations be in the hands of 100% Filipinos by way of stockholdings and management. The ownership and management of mass media shall be limited to citizens of the Philippines or to corporations, cooperatives, or associations wholly owned and managed by such Filipino citizens. Mass media has been defined as the source from where the general public gets their news and information. Mass media is also the technology that is intended to provide the masses with news and information. Historically, Philippine mass media started with newspapers. And I remember in the 50s, the very popular newspapers would be the Manila Times and the Manila Chronicle, which used to be owned and controlled by the Lopez family. When mass media started progressing technologically, radio took over as the dominant medium of passing on the news and information to the public. And the more popular radio stations in the 60s would be, of course, DCBB, DCRH, and DZXL. DCBB is a GMA organization, at that time still under Bob Stewart. On the other hand, DZRH was under the Manila Broadcasting Company of Elizalde, and DZXL, including at that time also, I guess DCMM was starting to evolve, was under the ABS-CBN group. Technology further modified the mass media picture in the Philippines when television, initially black and white, and later on the color TV entered the scenario in the 60s, late 60s and 70s. And this is where ABS-CBN came in very strongly with Channel 2, and Channel 7 was for GMA, Channel 9 was also ABS-CBN. DCRH and Channel 11, but when martial law was declared in 1972, the ABS-CBN group lost control, or the Lopez's lost control of ABS-CBN, and this was taken over by the Benedictos Canlaon Broadcasting Company. Finally, today, television has yielded in its popularity among the young people to the internet. And so the internet is the latest, more popular type of mass media mechanism. So all told, these four types of mass media mechanisms, the newspaper, radio, the television, and now internet, are all in place in order to bring news and information to our people. Now let's move on to the subject matter of the requirement that mass media organizations, notably broadcast media of radio and television, should be in the hands of 100% Filipinos. Now, the fundamental law on citizenship is that the domestic law of the country or state to which a person attributes his citizenship governs, the rule of that the domestic law of that country governs and determines whether a person is a citizen of that state or country. So that if the question on whether or not a person is a Filipino citizen, it is Philippine law that will govern the status of that particular person. On the other hand, if a person claims to be an American citizen, then it is American law that will determine whether or not he is an American citizen. So, if the issue is whether or not a person is a Filipino citizen, American law or Australian law or the law of Japan or the law of China would not have the authority to determine whether a person is a Filipino citizen. It is only the law of the Philippines on citizenship that will decide on whether a person is a Filipino citizen. In the same light, a person who claims to be an American citizen cannot claim that under Philippine law because Philippine law is irrelevant and has no jurisdiction nor authority to make such a pronouncement. A person who claims to be an American citizen has to go to the U.S. law and determines what are the requirements of U.S. law in order for him to claim that he is an American citizen. This brings to the picture now the more interesting topic of international law, especially affecting the civil status and citizenship of persons. First, the law of the country is called domestic law in relation to international law. And so the Philippine Constitution, the provisions of the Civil Code and the Family Code, the corporation law, the law on insurance, banking laws, intellectual properties, or the revised penal code are all Philippine laws that constitute the domestic law of the Philippines. In the same light, the U.S. Constitution, all of the laws affecting their civil and criminal aspects would be called the domestic law of America. And so therefore, the laws involving citizenship may differ between one country to another. For instance, in the United States, which follows the tradition of that they inherited from England, is that they follow the so-called common law. And in the recognition of citizenship, common law follows the principle of a person being citizen of the place where he was born. So it is the place of birth, otherwise in Latin called the principle of jus soli. So under the American Constitution, a person born in the United States is considered an American citizen. On the other hand, Philippine law essentially has been influenced by our 300 years of being under the Spaniards. And Spanish law followed the practices and the structure of Roman law. And having said that, the Philippines adopts, for purposes of determining the citizenship of a person, the so-called blood relationship principle, or otherwise known in Latin as jus sanguinis. In Philippine law, regardless of where a person is born, his citizenship is determined by the nature of the blood that flows in his veins. So that when a person has a father whose blood runs into his veins. That Filipino blood in his veins under Sanguinis makes him a Filipino citizen regardless of where he was born. Now, in the 1935 Constitution, what governs is the blood of the father. And so, under the 1935 Constitution, whoever was born with a where Filipino blood of the father runs into his vein is a Filipino citizen by natural birth. When the 1973 Constitution was formulated and later on followed by the 1987 Constitution, our Filipino framers and policymakers determined that citizenship by blood will continue, jus sanguinis. However, this time, it is not only the blood of the father running into the veins of his child that determines his natural-born citizenship, it is also the blood of the mother running to the veins of that particular person determines his Filipino citizenship. So when a baby is born, the blood of his father, which is Filipino, is running in his veins, then he is, by provision of Philippine law, a Filipino citizen. On the other hand, if his mother is a Filipino citizen at the time of his birth, and therefore in his blood runs the blood of his mother, which is Filipino blood, then that also qualifies him to be a Filipino citizen. More reason, if his father provided blood which is Filipino, and his mother provided blood which is Filipino, he is a Filipino citizen through and through. He needs only one type of Filipino blood, either from the father or the mother, to make him Filipino. Now, very interesting is when the father provides the Filipino blood to him, but the mother is a non-Filipino, then this particular born baby is a Filipino citizen because he is carrying Filipino blood coming from the father. Under the 1973 and 87 Constitution, this was further modified to give importance to the mother, so that those who are born from 1973 onwards up to today, and the mother is a Filipino citizen, therefore provided the born baby with Filipino blood, that baby is a natural-born Filipino citizen. It does not matter whether his father, whose blood also runs in him, is a non-Filipino. Now, what makes this very interesting is when there are now mixed marriages where the father is a Filipino and the mother is a non-Filipino. Or the other way around, when the father is non-Filipino and the mother is Filipino. In either case, when the father is Filipino, regardless of whether the mother is Filipino, that particular baby born, regardless of the place where he was born, has Filipino blood coming from the father. He is a natural-born Filipino citizen. In the same light, his father provided him with a non-Filipino blood, for example, American, Chinese, Japanese, Korean, or who knows, Saudi Arabian. So he is carrying with him, this born baby is carrying with him a non-Filipino blood in his veins. But his mother provided him with blood which is Filipino. Then that born baby is Filipino, a natural-born Filipino citizen, regardless of whether or not his father is a non-Filipino. Having said that, This is what makes the situation of Mr. Gary Lopez very interesting. Lopez, by chance, was born in Boston, Massachusetts, sometime in the early 50s. And so, using American law, domestic American law, and by reason of the principle of jus soli, citizenship by place of birth, Gabby Lopez is an American citizen under American domestic law because he was born at in the United States of America. However, what is significant is at the same time his father was a Filipino citizen and his mother is an American citizen, so that in his blood is running simultaneously the father's Filipino blood and the mother's Filipino blood. And so wherever he was born, he is a natural born Filipino citizen under Philippine domestic law. And so therefore, under international law, they have coined for practical reasons what is called a person with dual citizenship. So under American law, Gabby Lopez is an American citizen. And under Philippine law, he is a Filipino citizen. But mind you, Philippine law cannot decide, and it is beyond its scope of authority and competence to rule that Gabby Lopez is an American citizen, because it is only American law that determines that he is an American citizen. Philippine law can only make a pronouncement that he is a natural-born Filipino citizen. It is not, Philippine law has no jurisdiction or authority to resolve that he is also an American citizen. That is outside of the scope of the power of Philippine domestic law. In the same way, American law can declare him to be an American citizen by reason of its jus soli principle, but American law cannot make any pronouncement insofar as his Filipino citizenship is concerned. So that he is an American under American domestic law, and he is a Filipino citizen under Philippine domestic law. And the subject matter of being a stockholder in ABS-CBN is a question of resolving what is the citizenship of that person. Gabby Lopez is a Filipino citizen, and Philippine law has the authority, jurisprudence, and competence to rule that. But Philippine law will have totally no say, no jurisdiction, no competence, no authority to rule that he is an American citizen. So under Philippine law, Gabby Lopez qualifies to be a stockholder of ABS-CBN, where a mass media company like ABS-CBN mandates under the Constitution to have shareholders who are 100% Filipino. As an interesting side note, if there is such a thing in international law as a person with dual citizenship, is there a possibility that a person does not have any citizenship at all in relation to any country whatsoever? In the study of international law, the case of June Labo, that very famous faith healer from Baguio, reminds us of a person who ceased to be a Filipino citizen but also did not acquire any citizenship of another country. There was a time that Jun Labo married an Australian wife. And he made up his mind to settle down in Australia. And having therefore the idea that he will probably stay for the rest of his life in Australia, he decided to acquire Australian citizenship. But the application for Australian citizenship requires that the person so applying would now waive his loyalty and allegiance from one country where he's coming from to pledge allegiance in favor of Australia. And so in the process of application for Australian citizenship, Jun Labo took an oath to relinquish his Philippine citizenship. And at that point, a natural-born Filipino, Jun Labo, has lost his Philippine citizenship. However, subsequent events created a situation where the Australian authorities did not approve of Jun Labo's application for citizenship in Australia. And so at that point, that the Australian authorities refused to grant him Australian citizenship, he did not acquire the citizenship of an Australian. And so he was not an Australian citizen. But prior to that, he also relinquished his being a natural-born Filipino citizen. So he is not also a Filipino citizen. During that interregnum, Jun Labo is considered a person who is stateless. He is one of the classic examples of a stateless person. Of course, he came back later and it looks like he must have reacquired his Filipino citizenship, and that's provided for by law. But there was a point in his life that Jun Labo was a stateless person. In closing, I submit my hypothesis that the fact that Gabby Lopez is an American citizen under American domestic law is irrelevant to the issue that he is a Filipino citizen and is being a stockholder and a senior manager of ABS-CBN meets the requirement that ABS-CBN, a mass media company, meets the requirement of 100% Filipino citizenship. This is your Dean, Joe-Santos Balagtas Bisquera, sharing with you the inputs to the current controversy on the citizenship issue of Gabby Lopez in relation to the application of ABS-CBN for a legislative franchise. Thank you.